What is the history of legal protection for queer families? Imagine a world where love and family are recognized and protected for everyone, no matter who they love. Over the past century, laws have slowly changed to support queer families, but it has been a long journey. In the early 1900s, queer families faced strict legal discrimination. Courts often denied custody of children to LGBTQ+ parents, especially after divorce, because they saw homosexuality as incompatible with parenting. It was a tough time for families trying to build lives together. Things started to shift in the 1970s when some courts began to recognize the rights of gay, lesbian, and transgender parents. They allowed custody rights, but often with restrictions. For example, parents might have been allowed to keep custody if they did not live openly with a partner or openly engage in same-sex relationships. It was a small step forward, but progress was slow. The 1990s marked a turning point. The World Health Organization removed homosexuality from its list of mental disorders in 1990, which helped change societal attitudes. Countries like Norway and Denmark introduced registered partnerships for same-sex couples, giving them legal rights similar to marriage. In the United States, states like Vermont and Massachusetts started allowing same-sex couples to adopt children. Canadian provinces, such as British Columbia, also began to recognize these families. During the late 1990s and early 2000s, many countries created legal frameworks like civil unions or registered partnerships. These gave some rights related to inheritance, taxes, and healthcare but did not fully equal marriage rights. The Netherlands became the first country to legalize same-sex marriage in 2001, setting a global example. Other countries followed, and by the 2010s, many places had expanded marriage rights to include same-sex couples. In the United States, the fight for marriage equality gained momentum. Many states legalized same-sex marriage, and in 2015, the Supreme Court made it legal nationwide in the case of Obergefell v. Hodges. This decision also helped secure parental rights and spousal benefits for queer families. Adoption rights also expanded, with most U.S. states lifting bans on gay and lesbian individuals adopting children by 2010. Same-sex couples could now adopt jointly, helping to create blended queer families with legal protections. Anti-discrimination laws also played a big role. South Africa was the first country to explicitly prohibit discrimination based on sexual orientation in its constitution in 1994. These protections help ensure queer families are treated fairly in housing, jobs, health care, and social services. For blended queer families, these legal advances mean more stability and security. Recognizing relationships and parental rights helps families navigate life stages like marriage, adoption, and aging with confidence. It allows families formed through assisted reproduction or previous relationships to be acknowledged and protected by law. Understanding this history shows how legal protections have grown from almost no recognition to a more inclusive system that supports the vibrant diversity of queer love and family life today. It's a story of progress, resilience, and hope for a future where all families are valued and protected.